Hello, everybody, and good morning. We are going to be hearing everything on the Chad Daybell case this morning. Also, there's some other things I want to talk about while we're waiting for this to start. It's starting in about 30 minutes. Hello, Courtney. Hello, Courtney. We're going to go over that, Courtney. Here's my sister. Hello, sister from a different mister. Please smash that like button on your way in. Let everybody know that we are live. Nana, there's Nana. Hello, Nana. So I've got a little bit of information too on the Lori Vallow case that's going on. So if you have not subscribed, hit that subscribe button, hit the notification bell, and please give this a like. Alicia, hello, good morning. Good morning. So let's talk about that for a minute first. Lori Vallow, she's got a case pending in Arizona. There's a conspiracy to commit, regarding Charles Vallow, and also a conspiracy in the attempted, of Brandon Boudreau. Now, her case is pending again there. I believe that she is back in treatment. So what is going on there? She was scheduled to start her trial April 4th. Now, to today, we've got court coming up. You're going to see it right from the courtroom here. I'm allowed to live stream it, so we're going to stream it here. It starts in about 30 minutes. Chad Daybell's lawyer, John Pryor, is wanting off the case. So I'm going to present this. There we go. We went over this. Good morning, Courtney. We went over this the other day, but I'm going to go over it again because as I've been thinking about this, it's like this guy is a slimeball, this John Pryor. He has had 3 years to prepare for this case, and now he's saying, we can see right here, remaining on this case, we require the undersigned counsel to work around the clock more than full time for more than 4 months without compensation and without assistance of any other counsel. So what I have a problem with is he is known for a year that Chad Daybell has no more money. Let's talk about money. Good morning, Sarah. So now he's saying that Chad Daybell wants 2 death penalty qualified lawyers on the case. John Pryor wants off the case. The way I see it is he knew a year ago that Chad Daybell had no more money. He already owns Chad Daybell's house and property where the children were found buried. He's probably taken every last red cent that Chad Daybell has. And now he has no more money. He's known this for over a year. Hello, Judy. Norma, hello. So to me, he says that, let me just see right here, Mr. Daybell retain the undersigned counsel with personal funds. At a hearing on January 19th, 2023, this court inquired of Mr. Daybell and declared him indigent. So they've known about this for a year. Okay? He doesn't have the ability to pay for counsel continued services. And Mr. Daybell seeks the appointment of 2 capital qualified attorneys to represent him at this time. Number 1, John Pryor will never take second seat to anybody. John Pryor wants to be in the limelight, and that's what he's done for the last 3 years. Okay? He has wanted the spotlight. He wanted to be the only lawyer on the case because he knew over a year ago, that the death penalty was on the table, right? So as this court is aware, this case is both extraordinary, complex, and the prosecution is seeking the death penalty. You've known that for a long time, which requires counsel to essentially prepare for 2 trials because you have the trial, and then you have the death penalty phase, right? reflecting this complexity and the work required to prepare and try this case. The court has set aside 2 full months for a trial, and the prosecution team consists of no less than 5 attorneys from 2 county offices, including out-of-state attorney, blah, 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 blah. Remaining on this case, we require the undersigned counsel to work around the clock. This motion is made with Mr. Daybell's full consent. Mr. Daybell has requested for me that he be given 2 capital qualified attorneys for his trial. I have made diligent effort to find a lawyer to assist in this matter for a significant amount of time. I call BS. What has happened was John Pryor didn't want Chad Daybell's money going anywhere else but to him. He owns Chad Daybell's house and land. He has gotten every red cent from Chad Daybell that Chad Daybell had. He did not want to share that with anybody. So if he's been classified indigent, and this is the reason that you want off the trial, Mr. Pryor, why didn't you do this a year ago? That would have given time for other attorneys to have a year to get ready for this trial. Why didn't you do it? This is why he went and tried just months ago, tried to have the death penalty taken off the table. Why would you even do that? Number one, if the death penalty had been taken off the table, he could have remained on the case as the only lawyer and gotten all the funds, every red cent Chad Daybell had, including the property that he owned. John Pryor now owns. He owns everything. And he didn't have to share that with any other lawyer. So that's why he was trying to get the death penalty removed. So he could stay on this case and then possibly be paid by the state. But now, because they didn't get the death penalty off the table, and I said this in that video that I did live with you guys, I said, you watch, he's pulling something. There's something up their sleeve. I thought they were going to try and make a plea deal to take the death penalty off. I'll plead guilty if you take the death penalty off. But no, they didn't do this. This is what they've done. I want off the case, start over with new lawyers. So all this money that Chad Daybell has invested, he lost his house, everything. Does that mean that his 2 girls that is living in that house is now going to be evicted? Right? Marie, hello, my love. Upe, hello. Hello, hello. Hello, hello, hello. So he has gotten every red cent that he can get. Lori Forbes, good morning. Hello. And what the judge can do is keep him on and get a death penalty qualified lawyer to take first seat, which means John Pryor would be taking second seat, and you don't want no part of that. I've gotten every bit of blood out of him I can get. Deuces, I'm out. See ya. Kick rocks. I'm gone. 2 months before trial, 2 months and a bit before trial. He was supposed to be going to trial April 1st. Lori was supposed to be going to trial April 4th. Lori's not going to go to trial April 4th. She's back in treatment. Incompetent, whatever they're claiming. And it doesn't look like Chad's is going to go ahead April 1st, which means all this, not only did Chad just get bled dry, even a property he owned, and now John Pryor's going, deuces, I'm out. Not only that, now they're going to have to appoint other lawyers, and it's going to take at least, this is not going to go to trial until 2025 by the looks of it. Late 2025. If they have to have other lawyers come in and take over everything and start again from scratch. John Pryor used that money to pay experts, to pay for his time, his court appearances, all this work that he's been doing. It's got to be paid all over again because these new lawyers are going, if this is what happens and he's off the case, these new lawyers are going to want their own experts, their own testing of the evidence and everything else. All this is going to have to be done all over again, including going through motion after motion after motion again. There's hundreds of filings. There's got to be 100 and something times they've appeared in front of the judge. That's all going to have to happen again. There's going to be disclosure issues. There's going to be all kinds of things. They're going to want to hire their own experts. They're going to want to retest everything. All that court time and money wasted. So I hope the judge sees what John Pryor is doing and reprimands him to the full extent he can. Don't tell me that you've spent significant amount of time to get death penalty qualified. You could have asked the court's help a year ago, and that lawyer could have had a year. But no, Mr. Pryor, you didn't do that, because at that point he still had some, well, just before that, he still had some money, and you would have had to share that money with another lawyer, and you didn't want that. You didn't want it. You wanted the money all to yourself. Every little blood piece of money that Chad Daybell had, including his properties that he owned. So that's my opinion on it, you guys. He said that he's spent a significant amount of time trying to get somebody qualified. Well, you should have got one that was already qualified. And if you couldn't do it quickly, last January, you should have asked the court to appoint you now and the state pay for you and a death penalty qualified lawyer. That should have been done a year ago. And the judge better do something about that. Yes, please hit that like button on the way in. So we got about 20 minutes, you guys, before this started, but I wanted to go live a little bit earlier so I can go over some of this with you and see what you guys have to say about it in the chat. What do you guys think? With that information, what do you guys think? Do you think he was just bleeding him dry for as long as he could? And why wouldn't he have tried to get off the case a year ago when he was considered indigent a year ago? Why did he wait till now, 2.5 months before the trials to start? Why didn't he hire or get the court to appoint a death penalty qualified lawyer a year ago or more? What do you guys think? Do you think along the same lines as I do, is that he wanted every cent to himself, and having another lawyer on the case would have taken away from what he was going to get? That's when Chad was paying him himself. What do you guys think? Let me know. I'm watching the comments here. Let me know what you think. It'd be interesting to hear what you guys think. And it says here, because Mr. Daybell is facing the death penalty and he has been determined indigent, he is statutorily entitled to appointment of 2 counsel who are capital qualified at state expense. Yes, that is true. Okay. Point being, it should have been done a year ago. A year ago. Absolutely. And this is what I said a couple months ago. He's gonna pull something. And this is what they're trying to do. Well, I'm off the case. I'm not death penalty qualified. I'm off the case. You guys got to start all over again from square one, which is you're into $500,000, if not more, in court stuff, and I'm sure at least $500,000 in attorney's fees at this point that's been paid to John Pryor. Chad no longer even owns his house. John Pryor does. Lori says, I agree. Vera Moy too. Everybody, I think, is agreeing. Absolutely. Courtney says, I absolutely agree. To be honest, it's no more than Daybell deserves. However, JJ and Tylee, Tammy deserve better. Yes, they do. And the court system deserves better. He played the system. You don't bleed somebody dry and then say, deuces. When you've had over a year to get a death penalty qualified lawyer, and if you couldn't do that on your own, then the court would have done it for you, but you didn't ask for it. The court doesn't know what you have and what you don't unless you present it or you say you don't have it. He could have had a lawyer he hired that the court doesn't know about. But now it's getting down to the nitty gritty when they've got to do all their disclosures and everything and have everything filed, witness lists, everything filed. Now you're coming out with it. He wanted every cent that he could bleed. And yes, Chad Daybell deserves a death penalty, and I pray to the Lord above that he gets it. But in the same aspect, you guys, he was bled dry. Does he deserve it? Yes, but you got to look at the whole picture. The victims deserve better. Well, I'm anxious to see what the judge is going to do in this matter. He is entitled to a death penalty qualified attorney. But at this stage of the game, when he is set to go to trial in 2.5 months, there should be some kind of consequence for what he has done. And I hope the court sees what he did. And goes on to say the Idaho State Public Defense Commission maintains a roster of capital qualified attorneys. See? And that's what you should have asked for a year ago. While undersigned counsel could accept appointment to this case if it were non-capital, because Mr. Daybell is now facing the death penalty, undersigned counsel cannot be appointed pursuant to the statute. The counsel therefore moves to withdraw. That's BS. He can still be appointed, but he would have to take second seat, which means he's not in control anymore. He's got a say, but a death penalty qualified lawyer would have first seat, which means full control. John Pryor is like hired help at that point. So it's not, the state can still appoint him. Oh, it's dirty, all right. It is really dirty. Yep. Like I said, he owns Chad Daybell's house and property. Every friggin' cent that he has, blood money that he has or had, is now in John Pryor's bank account. And I can guarantee you he's going to sell that house. He's going to kick out Chad Daybell's daughters, and he's going to sell that property, and he's going to get more than what it's worth because of the notoriety. There's some sick people out there that are going to, if that house, say, and this is just a hypothetical, say that house is worth $500,000 with the property. He's probably going to get double just because of the notoriety. There's some sicko out there that's going to want it. I don't know why some pages are. So notice is hereby given on the 30th day of January, right? Thank you, Sarah. I appreciate it. It really helps keep these lives going and for me to set aside time to be able to do this for you guys. So notice is hereby given that on the 30th day of January 2024 at the hour of 9:30 a.m. or as soon thereafter as counsel may be heard, John Pryor, attorney for the defendant above named, will call up for a hearing for the defendant motion to continue before the Honorable Judge Stephen Boyce, Fremont County. So I do believe that it is going to be heard today. There's also another hearing that was scheduled for the 29th or the 30th. I don't know if that one is still going to go through, depending on what is decided today. Brian Koberger is back in court next Friday. I will be covering that one also. So yes, every bit of donations to the channel helps me to be able to put aside time to be able to bring you guys these lives and live coverage. Leslie says, I couldn't live there knowing what happened. Me either. But there's some sickos out there. Again, thank you, Sarah. Thank you. I couldn't live there knowing what happened. Me either. But there's some sick people out there that want it. Nana says there are 13 death penalty qualified lawyers in Idaho. Yes, thank you so much, Sarah Smith. You're awesome. So we're going to see what, and on top of that, you guys, he wanted this, he wanted it sealed. He wanted this sealed. Let me just find, we got a few more minutes before this is supposed to start. Let me just find. And there's nothing yet in the Koberger. Oh, what's this? What's this? Okay. What's this? Okay, why is that under Kobergers? Hang on a sec, you guys. Let me just scroll up here. I think they filed something wrong. Oh, yes, they did. Okay, let me show you this, you guys. I'm going to show you this. Okay, so you can see this is State of Idaho versus Brian Koberger. Now, if you scroll down, these are all the motions to seal and everything else. You scroll down. This is all the paperwork that's been filed into Koberger's case, right? Scroll down, scroll down, scroll down. These are all his. We haven't seen a new name pop up. Okay. Look at this. Public order for disclosure of IGG. Okay. Just to show you guys we're still on Brian Koberger. Okay. See, Brian Koberger. I just opened this one, the IGG. Listen to this. Look at here. They filed this under the Koberger case. Look at Chad Daybell. Look at amended notice of hearing. Chad's is here underneath. This is under Brian Koberger's. They filed it wrong. They filed Chad Daybell's information under Brian Koberger's information. See, right above it, order denying request for approval. Look at this. And this is stuff that I hate, you guys. Look at Chad Daybell. Another one. Okay. Let's go to the one above it. Motion to unseal defendant's motion to reconsider. Whose is it? It's Brian Koberger. They filed this under Brian Koberger's file and not Chad Daybell's. Chad Daybell's start here and goes down. Look at, this is all, look at, we'll scroll up. These are all, look at, these are all Brian Koberger. See, Brian Koberger. Let's scroll up. What a bunch of idiots. They filed it under Brian Koberger's. There, Brian C. Koberger. This is, look at, from the time of his arrest. And then we scroll down through all of his stuff. This is just supposed to be all of Brian Koberger. Brian Koberger. I thought I made a mistake there for a minute, but I didn't. Look at, what a bunch of idiots. Right? That's the court. Like, what the hell? Lori says, that's why I don't miss working in a law office. Well, I did too in criminal law for over 30 years. And this is the first time I see something like this. Believe it or not, it's the first time in my 30 years I've ever seen something like this. You've entered orders and everything else because this is an order. This is the judge's order in the Daybell case, and you filed it under the Kohlberger case. Idiots. See, here's where Chad Daybell starts, and this is Brian Kohlberger's. See? Disclosure of IGG. This is Brian Kohlberger's case file. Oh my God, you guys. Anyway, there you go. Can you believe that? Hang on, I'm going to screenshot this. Okay, give me a second, you guys. Okay. There, I just posted it under my community tab. I have not seen anybody else catch that yet. Right, TK? Sarah. Unreal. Now I forget what I was even looking for. Let me just check. And make sure, because they will be starting within 5 minutes, you guys. So I got to keep an eye on that. Now I forget what I was looking for. I was looking for something in the Chad Daybell. Good thing I checked that, right? Okay, that's what I was looking for. Share screen. This is what I was looking for. So now we're at the end of Chad's. Order to unseal, notice of hearing, motion to withdraw as counsel, motion to seal. So we're missing some documents in this file because they were filed in under Brian Kohlberger's file. See, he did a motion here to seal. That's what I was talking about. My memory's getting better, you guys. On the 11th of January, says, comes now the above named defendant Chad Guy Daybell by and through his attorney of record John Pryor and pursuant to ICAR, and moves this court for an order sealing the motion to withdraw as counsel and declaration of counsel in support of the motion to withdraw. He didn't want anybody to see it. Hello, Butterfly Dana. Nice to see you, my love. It's going to be starting any minute, you guys. I am keeping an eye on it. So this is why I couldn't find those filings because they filed Chad Daybell's motions and orders in Brian Koberger's file. Idiots. So this is where he wanted to seal his motion. And the judge said, no way. No way. He filed it under seal and the judge unsealed it. See, the order to unseal. So the judge unsealed it. We don't have time to go through all this, but the judge unsealed it and put this for a public hearing on January 18th. And that's what we're waiting for right now. Unreal. So that's on my community tab, you guys. I just posted it where it shows that they filed Chad Daybell's some orders that the judge made and some motions that were put in. They didn't file it in Chad Daybell's file. They filed it in Brian Koberger's file. So I am keeping an eye on the courts here. You know, they're always a little bit late, you guys. So I am watching for it to start as soon as... Oh, give me a second, you guys. Son of a bitch. Now I forget what I was just looking up. I finally, after jumping through hoops, you guys, got an appointment for my MRI for my back. They had lost the requisition. They had lost the x-rays. I had to go get new x-rays. They had to find the requisition. They had to call my doctor's office. My doctor had to send another one. Finally got it for February 2nd, and that was the hospital that just called and said, we have to postpone. Our machine's going to be down that day. Was it working today? Yeah. Well, how do you know it's going to be down that day? So it's been postponed again, you guys. Oh, peeved me off. Anyway, what am I looking for here? Here we go. Nothing yet, you guys. You know, they always run late, and I'm sure John Pryor right now is pooping his pants. He's probably in the bathroom changing his diaper. But as soon as it starts, I will be bringing it to you. As soon as it's up on, let me just see over here. So the state has filed an objection for John Pryor withdrawing. We don't see that. Lord knows whose file they filed that in. We just seen that he had filed wrong stuff in somebody else's file. So let me just go back over here for a minute, you guys. Just checking something here. Oh, come on. Oops. Okay. So the has filed an objection. And it's still not up yet, you guys. And you guys know they're always late, but as soon as it does pop up. Hey, K Mitch, it hasn't started yet, as per usual. They're always late. So we're just waiting for it to start. So hang on a second, you guys. Oops. Come on. We're just waiting for them to start, you guys. I am keeping an eye on it here. It has not started yet. As soon as it does, I will put it up on screen. Why is Idaho always late? I don't know. Well, you just seen how they mishandled files, so. Okay. Oh, come on. Every time you, oh, there they are. It just started.
Daybell.
Put one in the chat, you guys, if you can hear it.
This morning is a hearing on defense counsel's motion to withdraw. A couple of preliminary matters before we get started here. The court will note there is an order governing courtroom conduct. The court is live streaming this on the official YouTube channel of the Idaho Supreme Court.
Everybody can hear it.
Permitting any other
one. Ever got a lot of ones.
Video or audio of the proceedings. So if you have a device,
okay, I'm going to mute.
That's not permitted. In addition, if you do have devices that make noise, please make sure they're silent or turned off to not disrupt the proceedings. And that's all set forth in the order governing courtroom conduct that's in effect for this hearing. I'll note on the record that the state is represented this morning by Rob Wood and Lindsay Blake, prosecutors for Madison and Fremont County. John Pryor is here with the defendant, Mr. Daybell, and the court scheduled on shortened time today's hearing after receiving a proposed motion to withdraw as counsel. That was filed on January 11th. There was a declaration supporting the motion also filed January 11th. Court reviewed those and determined that the motions originally filed under seal would be unsealed, and they were. The state then, yesterday on the 17th of January, filed a objection to the motion to withdraw. I'll also note that the court entered an order just this morning that unsealed the previously sealed order of the court as it related to a August 25th, 2023 order. And I've provided copies of that to council, but it does have some relevance to today's proceedings, so let me confirm that. Mr. Pryor, you would have already had a copy of that order, but from the state, Ms. Blake or Mr. Wood, did you receive the court's order unsealing the August 25th from last year order and a copy of that order?
Yes, Your Honor, they were provided to council today.
Okay, thank you. And they're doing construction right through the doorway here, so council could speak up probably into the microphones, unfortunately. Try to make the record as clear as we can here. Mr. Pryor, are you ready to proceed on your motion?
Yes, Your Honor.
All right, and who will be arguing on behalf for the state today?
I will, Your Honor.
Ms. Blake. All right, Mr. Pryor, then, as I mentioned, I've reviewed the motion. If you'd like to submit arguments in support of the motion, you can do that at this time.
Judge, because of the microphone, may I have permission to remain seated?
You may, and if you just pull the microphone right up close there, Mr. Pryor, because of this noise from construction, that will be helpful.
And Judge, I was advised by your clerk that the microphones are doing quite well and that I should probably, and is my voice at this point acceptable, Madam Clerk? In terms of the tone, it's not washing out?
Yeah, it's fine. We're picking it up. Thank you.
Judge, I appreciate the court releasing the order from 8/25/23. The court's well aware ex parte that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel. I believe that was probably about 2 years ago. I started seeking a year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders, the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors and got the idea of maybe reaching out to out-of-state attorneys and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in Judge, I don't want to misstate, so I want to be very careful about this, but I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission. And at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made. And I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But it came to, I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court.
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval. At this point, this puts me in the situation where this court, I don't think, is obligated to appoint an attorney. Mr. Daybell has private counsel. And I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money. Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you
Right?
to work.
Now he's
the work it's
backtracking.
going to take to get it through trial without compensation. So
Right, and that's correct, Judge.
And he
this is
did
an
bring up
important issue
money.
for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand? But when I'm considering
Woohoo,
the
Judge
standards
Boyce.
under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial? Or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. The concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work. And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered, or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, All right, Mr. Pryor is granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get paid for the work that I do. And that's, you know, and if I was unclear in my my declaration, Judge, that's where I stand on this issue. But the only way for Mr. Daybell to get appointed 2 capital qualified attorneys, and the only, you know, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify. But at this point, I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial. But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No. But by the same token, primarily, Judge, is the only mechanism I can think of to allow Mr. Daybell to get 2 capital qualified attorneys to help him with this case is if I step away and withdraw from this case.
Prior, going back to your preparation for trial, of course, this is a capital case, and if there's a conviction in the case, then under Idaho Code 192515, there's a special sentencing proceeding. And Idaho has adopted ABA standards for capital defense cases, and generally that requires, for example, the appointment of a mitigation specialist for the defense team as part of those proceedings. And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Judge, if the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue because that is a trial issue and it's a trial strategy that at this point, I am not prepared to make an open statement on live TV about what my strategy is. If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this. In terms of the ABA standards, Judge, in terms of complying with the ABA standards, I'm aware of those standards. I'm aware of what that obligation is. But again, in terms of how I'm going to proceed in that manner, I would prefer to do that in either in chambers or in a closed proceeding.
Okay, and I think that's a fair enough request. Again, I'm not asking you to reveal trial strategy or publicly put that out, but these are legitimate concerns I have in weighing out whether or not Mr. Daybell is going to receive effective assistance of counsel in this case if you are permitted to remain on by me denying this motion. So I do want to get into that issue and discuss that. The state's entitled to know the answers to that as part of their objection to this motion. In lieu of doing that in chambers or off the record, it's got to be on the record. It needs to be in a sealed closed portion of the hearing. I'll determine under ICAR 32 And I think really the best way to do that, unfortunately, at the inconvenience of those in attendance here, is likely to clear the courtroom and allow that discussion to take place with only those necessary personnel in here to conduct the proceedings as part of a sealed closed hearing. So that's what I'll do at this point, to go through those issues, and then we'll come back on in a public proceeding. So I would request that courthouse security and the bailiffs, if we could have everyone step out except for the clerk and the necessary security.
Okay, so
While
they're
Mr.
going to clear
Daybell
the
is
courtroom,
here,
but
we
they will be coming
close this
back
portion
after
with the
they
proceedings,
discuss
and
what they're
also,
going to discuss.
For the bailiffs, if you could just make sure no one's within earshot of the a doorway as well, to make sure it's not carrying through on the microphones. And I appreciate your accommodating that.
And then they
We'll
will
also,
come
of course,
back.
stop the proceedings from being live streamed, and then we will come back on the record once we're ready. We'll take a brief recess while that occurs.
All rise.
Okay, so they're clearing the courtroom. They're going to take us off Zoom. So we will pop back on that when it is back for the public to see. They are going to have an enclosed session right now. I guess I could leave that up. Okay, I can leave this up. I didn't know what they were going to do. Okay, I will leave it up so we know when it comes back on. So right now they're in a breakout session. They are going to be coming back. And it's like the judge called him out. So it's all about the money. It's all about the money, right? No, I'll do this for free. It's not about the money. But how many times did he bring up it's about the money? I'll continue to do this even if I'm not paid. Then why are we here? Because in his filing, he said he's not going to continue to work for nothing. That was his whole motion. He's not being paid, so he wants off the case. And now he's saying, when the judge calls him out, he's saying, well, I don't care if I get paid, but then follows that up with about 30 times saying, well, yes, I want to get paid. Yes, I want to get paid. Then, to the shock of everybody, he could have become death penalty qualified, and he didn't do it. So if you were that intent and saying, oh, I want to follow this through, and Mr. Daybell wants me still on this case, and I want to still do this case, then you would have gotten yourself death penalty qualified. Why didn't you do it? He meets all the credentials for it. Why didn't you do it? It wouldn't have taken him long. Maybe a week to get death penalty qualified, because he said he had all the credentials to be death penalty qualified. He just doesn't have that paper saying he is. Go get the paper. And then he could have hired just another lawyer to help him. Why didn't you do that? Dumbass. Because it's all about the money. Now he'd be death penalty qualified, and he'd be being paid by the state, which is not as much as he would make if he was being paid privately. He's already got all of Chad Daybell's property, his house, his land, everything the guy owns, he has. And he's gotten every blood money penny that Chad Daybell ever had. And now he wants to dip. And that's what his filing said. He was not being paid and he couldn't do it anymore. And then he says, well, I can't prepare. I don't have enough time to prepare. You've had 3 years. This falls on him. You should have got yourself death penalty qualified a year ago when you seen you couldn't get a death penalty qualified lawyer. You should have done it and hired on another criminal lawyer to help. And he didn't do it. Number one, because then the money that he was getting back then, he would have had to share that with another lawyer, and he wasn't about to do that. It is all about the money. So this is just a load of BS, if you ask me. And I do think the judge is seeing right through it. Oh, Judge Boyce is getting mad. No, he can't say ineffective counsel. No, because he's asked for him to stay on. It was just said in court, and it's on the record that Chad Daybell is requesting that he stays on. But in his filings, he's saying Chad Daybell said, no, I want 2 death penalty qualified lawyers. Well, if you can't get 1, how the hell do you think you're going to get 2? Right? It doesn't make sense. What do you guys think? Like, he's talking around in circles. He's digging himself his own grave. Well, it's not about the money, but how many times money do I want to get paid? How many times you got to say it? I counted 30. But it's not. Oh, I think Judge Boyce is going to have it here. And I said right at the beginning, there's other people, even other people that are on YouTube that are lawyers that were saying, you know, Judge is going to allow him to withdraw. I don't think he's going to. I don't think he's going to. I said that a couple weeks ago, and I'm sticking to it. If he does let him withdraw, I'm going to be very surprised. Now, that's based on what I'm hearing. I don't hear what's going on in this breakout session with this strategy thing that he's going to be talking about that Judge Boyce is going to take into consideration. Yeah, I do believe Judge Boyce is seeing right through him. Like, how many times are you going to mention, after saying it's not about the money, you don't care if you get paid or not, and then continue 30 times to say it's all about the money? Which one is it? You can't have it both ways. Right? And like I said, you guys, if he's off this case, he's probably made a deal with Chad. Like, okay, give me your property and everything, and I'm going to represent you. But if he goes off the case now because he doesn't have the help and it's not going to be beneficial, as he claims, to Chad, Chad's sitting there going, boop-de-doo, yep, well, he followed through with what he agreed. That's why I gave him my property, signed it over to him. He did everything he could possibly do. You know what John Pryor's going to do? That place is going up for sale. Chad's daughters are going to be thrown out, and that property is going to go up for sale. And if it's worth, say, $500,000, he's going to get at least double, because there's some sickos out there that are going to want that property because of its notoriety. Guarantee you. Marie says at least Boyce is seeing right through him. Yes, I do believe. Like, if I was the judge sitting there and you're looking at me, I seen your paperwork that you filed, even though it's filed in the Brian Koberger's case instead of in Chad's file. It's been filed under Brian Koberger. Go check out my community tab, you guys. I posted it there. I was looking for something and seeing, why is Chad Daybell's court filings, orders and judges' orders and everything filed in Brian Koberger's file? Not even filed in the proper file. But anyway, now I forget what I was saying. See? Yeah, so the judge says, well, I read your paperwork. It's all about money. Well, no, Judge, I've changed my mind. It's not about the money. I'll continue to work through this, but it's all about the money. I should be getting paid, and I want to get paid. But I counted 30 times. I don't believe he could. The thing is with that K-Mitch is he just admitted in court that he has every credential to be death penalty qualified. He just hasn't gone and done it, which would take him next to no time. Like, probably within a week, he can get death penalty qualified because he has all the qualifications. That's what he said. So why didn't you get death penalty qualified and hire another criminal lawyer to help you? Why? Because that would have taken money away out of John Pryor's pocket. Because there is a fee to become death penalty qualified. And then that puts him on a list that the court can call him onto death penalty cases. And then 90% of the time you are paid by the state, which means you're not going to get your full rate. And that puts him on a list where he agrees that if they need him, in Idaho, he's got to go. You know what I mean? Because he's death penalty qualified. Like there are things that are attached to that. And he didn't want to go ahead and do that. Well, if you just wanted to work on this case and keep this case and do everything for your client, why didn't you do that? You did not do everything in your power to stay on this case. Oh, I do believe he's going to be made to stay on the case. Shar, Truth Seeker, says, good day, Willow. I believe Pryor should be made to stay on the case. It is irresponsible and disgusting that Pryor could have a DP certification and chose not to. Right. So the judge heard that. I heard it and it was like, oh, you dumbass. Well, I got all the qualifications to become death penalty qualified and certified, but I didn't do it, Your Honor. I'd rather try and find somebody that I can't find and, get so far down the line that now this case is in jeopardy of going to trial on April 1st. He could have got death penalty qualified and hired on another criminal attorney for second seat. He chose not to do it because it costs money to get death penalty qualified. It's going to cost him. And then he's on that list in Idaho to be called in any case across Idaho in a death penalty case that he would have to go for. And he's only getting paid state rate instead of private rate. So I do believe this is all about money for him. Right? But he just shot himself in his foot. And he's had almost 3 years to prepare for this case. And now you say, no, I can't be ready. You were ready to go a year and a half ago. I want to go. Remember when this was connected with Lori Daybell, Lori Vallow? He's all rearing and ready to go. I'm ready to go. Oops. And all of a sudden, oh, you won't separate the cases? Okay, I'm not ready to go yet. We got to delay it. He did that so he could get that separation between the cases. He's been playing games all this time since the beginning. He played games so he could get the trials separated, saying he was ready to go, a trial date set. All of a sudden, oh, it's got to be vacated because I'm not ready to go now. That was to get the cases separated. Once the cases were separated, boom, he was ready to go again. But now all of a sudden you could not be ready to go? Like he's been playing games this whole time. I don't know if the judge can order that. But what the judge can do is order him on the case and order another death penalty lawyer. The judge can order that. A death penalty qualified lawyer to get on this case. But that's going to delay it. It's going to delay this trial. And I've said right from the beginning, there's a lot of lawyers on YouTube that have said, no, he's good. They're going to allow him to get off the case, blah, blah, blah. And I say, no, I'm still sticking to it. Like I said, I worked in Canada, I've worked in the criminal justice system for over 30 years. So I believe that he is going to be made to stay on the case. That's not hearing what's happening right now, too. I don't know what is going to come of the questions that the judge wanted answered. Because even if he goes through with this trial, there's still another phase, which is the death penalty part. It's like a mini trial within the trial. So could the judge order, John Pryor says he's ready to go on this, but he wouldn't be ready for the death penalty part of it because he's not death penalty qualified. Well, could the judge say, okay, you're going to do the trial. You chose to do it on your own so far. You could have hired another regular criminal lawyer to help you, and you didn't. So that's on you. So you're going to have to do this case now. And then come the penalty phase with the death penalty, we're going to make sure that you have a lawyer appointed death penalty qualified. He could do that too. I don't know. like I said, I can't hear right now his argument for the death penalty phase, which is what the last question the judge asked him. Are you going to be, I think he said, are you going to have those things in place for the death penalty phase part of it? And he didn't want to divulge anything, so they went in a breakout session. So I don't know what's being said there. I don't know. But from everything I know right now, I'm saying that the judge should be keeping him on. And I think he's going to get a stern lecture from the judge because he's had more than enough time to prepare. And now he's saying he's not prepared, but he was prepared a year and a half ago to go. He wanted to go, let's go. And then the only reason he vacated those trial dates that were previously set was because he wanted to separate Lori Vallow's case from Chad Daybell. And he finally got his wish because he kept vacating. But once that was done, now he's ready to go. Then he filed a motion to have the death penalty removed. And that did not fly. And I said right there and then, they've got something else up their sleeves. And this is what it is. I'm not ready now. I don't have a death penalty qualified lawyer. You've had over a year and a half. He stated it right in court. And he himself could have been death penalty qualified within a week because he himself said he has all the credentials to be death penalty qualified. But he didn't do it. No. I don't think she was the mastermind behind it at all. I think she went along with it, but I don't think she was the mastermind. I think they're both equally culpable at this point, as well as Alex Cox, but Alex Cox is no longer with us. So yeah, there's quite a few cases right now, you guys, in Idaho. We got the Idaho 4. We've got another case where apparently this guy, his wife and children were inside the living room window or whatever, and this guy was exposing himself through his window across from them. I don't know the details of it. I haven't looked into it, but was exposing himself and was doing things like that even when the kids were outside and stuff. I guess he approached one of this guy's kids. So the guy went over and took out everybody in that house, including this guy he called a pedophile. Took out everybody in the house, 4 people. So there's another one, just like the Idaho 4. There's that one that there was 4 victims also. It's death penalty. The Idaho 4 is death penalty. Chad Daybell is death penalty. So you got 3 that I know of right there that are death penalty, they're going for the death penalty in Idaho. If they've got 13 death penalty qualified attorneys in Idaho, even if you put 3 death penalty qualified lawyers on each case, you still got extras. That's only 9 on these 3 cases. The Idaho 4, where there was 4 victims, the other one where there was 4 victims, and Chad Daybell's. That's 9. If you put 3, if you only put 2, that's only 6. You still got 7 more. So what's going on here? I do believe that he is going to make him stay on. And this is what I just said. You say courts have paid private attorneys. Yes, because he's already invested in the amount of time that he spent and the amount of time the court has spent. They don't want to just let him walk now and have to restart all over from day one again. So the state would step in and say, okay, we're going to pay you, but it's only going to be state wages, not private wages. And I don't think Pryor likes that, even though he says, oh, it's not about the money. I do this for free. Well, then why do you keep mentioning 30 times, I want to be paid for this? So that's an issue. And will the state pay for him? Yes, they will. Oh yeah. Temper tantrum. And it's like you're contradicting yourself every time you open your mouth. Pryor, you got to shut up. And then the biggest one, and I'm sorry to repeat it again, you guys, but for John Pryor to say, I have all the credentials to be death penalty qualified, but I just didn't do it. Well, then you're not doing everything in your power for your client. You should have done that a year and a half ago when you found out that this was going to be a death penalty case. You should have automatically done it if you spent a month. And anything more than 30 days is unacceptable. If you spend up to 30 days trying to get a death penalty qualified lawyer to work this case with you and you couldn't get it, but you were qualified to become death penalty certified and you didn't do it, that wouldn't fly here in Canada. So I don't know what the judge is going to do, but I believe that the judge is going to make him stay on. The judge may even suggest he gets death penalty qualified. And he's going to appoint another attorney. That's what I think is going to happen. And that is based on everything I've heard up to this point. I can't hear what's going on right now in this breakout session. What else is John Pryor going to throw in there that we can't hear? I don't know. Is he going to say, look, I don't have the ability, means, or the methods to do the second phase of this trial, which is the death penalty phase? You still got a few months. You got 2 months that they put across for trial and 2.5 months. You got almost 5 months to get that part of the trial prepared. We're going to appoint you a death penalty qualified attorney for that phase. And he's got 5 months to catch up. So I suggest you start working 24 hours a day. We need to send him Pampers. I love that. Never really seen a case as big, would you? Right. And Leslie, the reason why he didn't want to bring on another lawyer is because he didn't want to have to pay that person. He wanted every piece of blood money and blood property that he could get from Chad Daybell. If he would have brought on another attorney, he would have had to share that. Right? He ain't about to do that. He owns that property where the children were found. He can sell that for double. That's why he's not worried about getting paid, he says. That property is his now. And if the judge takes him off the case, he can look at Chad and say, okay, I followed through my end of the bargain. I did everything humanly possible. No, you didn't, because you could have got death penalty qualified and you didn't. You could have hired another lawyer. You didn't. You could have had the court appoint one. You didn't. And he's going to walk away with that property, that blood money property, and blood money, every penny of blood money that he got, including the money that was probably long gone as soon as it hit his grimy paws after Tammy's death, when he got that insurance money. That was probably stowed away and hidden away. You know what I mean? He's got every dime that Chad had, and he never had to share it with anybody. Hey, Bad Monkey. No, we're just in a breakout session right now because John Pryor has some more crying to do. He's just shot himself in the foot many times. Rewind a bit and you'll see it. He says it's not about the money. The judge says, well, that's what you filed. It was about the money. You're not getting paid, and you can't continue to do this because you're not getting paid. And now you can't be prepared, even though you've had 3 years to prepare. You've had 3 years to, hire other attorneys to help you. You chose to do it yourself. John Pryor come out with, well, I could have been death penalty certified, but I didn't go ahead and do it. So he didn't do everything to his ability for his client. And now he wants off the case now that he's gotten every piece of blood money and property that he could get from Chad Daybell. He wants now off the case. So that's where we're at right now. The judge, before the break, the judge asked him if he could be prepared for the second part, which is death penalty phase. Are you going to have the everything in place for that? And he said, oh, well, I don't want to put all my information out there and blah, blah, blah. So he wanted a breakout session. So that's what they're doing now. That's where we stand, to make a long story short. And even though all through the first part of the hearing that we've already heard, John Pryor claiming that this isn't about money, over 30 times he made it a point to say it was about money. So that's where we're at. Yeah. Right? This has been a shit show, you guys, right from the beginning. Right from the beginning, this has been a shit show. So we are just waiting for them to come back from this breakaway session where I can just imagine what John Pryor is saying in that breakout room. I don't know if that's public record there, Shar. Be interesting to see, though, if we can see it. Pryor was doing Marie. Pryor, I feel, Marie Burke says Pryor has been a shit show. I think he's done a semi-good job, but it's his intentions that were behind it that are now coming to light. He wanted to, how can I say this? He wanted to drag this out as long as he could to make sure he had every red cent of blood money, including blood money property, Chad's house. And I guarantee you that if he is taken off this case, Chad's daughter's going to be thrown out of that house, and John Pryor's going to put it up for sale, and he's probably going to get double or triple what it's worth because some sicko out there is going to want that property for its notoriety. I don't know. Sarah Smith says, Willow, I pray that the judge makes it mandatory for John Pryor to stay on Chad's case. Pro bono. I don't know about pro bono, and I wonder if he was able to be a DP attorney. He could. He said he has all the credentials to become death penalty qualified and certified, but he chose not to do it. Come on, you guys, while we're waiting, smash that like button. 49 people here, 39 likes. Please smash that like button and get it out there in the algorithm. Help me out because I take a lot of time out of my day to bring you this. So the super chats and everything help for me to continue to do these live coverages. Otherwise, I would just record it all and then show it at a later date. But I'm doing it live, so super chats and PayPal and everything, it all helps for me to set aside the time, you guys, to continue to bring this to you live. Thank you guys for smashing that like button. I appreciate it. Oh, all of it. All of it was avoidable, Shar. All of it. Like I said, I continuously continue to state this. He just shot himself in the foot when he says, well, it's not about the money. I do this for free. But then 30 times says he wants to be paid. But then he'd said he's got all the qualifications, all the merits, everything to be death penalty certified. He just didn't do it. Doesn't want to do it. So then you didn't do everything in your power for your client. But you took every piece of property, house, vehicles, campers, this, that, tools, whatever else he took, including cash from Tammy's life insurance. You taken every piece of blood money thing that you can from this guy. You know what I mean? And you didn't do what you could have done to become death penalty qualified, which would have taken you a couple days. All he does, the only thing he's missing is the paper. He said it himself. He's got all the credentials to become death penalty qualified, but he just didn't do it. Oh, Judge Boyce's blood pressure must be, like, you could see his forehead. It was all red. When they come back, watch Judge Boyce's forehead. It's red. I wish I was a fly on the wall right now in this breakout room. So he hasn't done everything that he could do because he could have become death penalty qualified and then hired another criminal lawyer to assist him, which he did not do. Here in Canada, the Upper Canada Law Society would pull your license for something like that. So we are just waiting for them to come back, you guys. Thank you, you guys. I see you guys smashing that like button. Thank you. 52 in here, only 43 likes. Smash that like button. Go on out of chat. Smash that like button. When you come back into chat, make sure you have live chat selected at the top of your chat box so you don't miss anything. Oh, I can just imagine, share what's going on in chambers right now in the breakout session. Thank you, Nana. Thank you, Nana. Sarah, please mask your words. Yeah, YouTube has really we just got all the creators across the board, whether you're in the true crime community or not. Everybody is put on notice, you guys. We are all been put on notice about things that we can do. They brought new rules in considering doxing and bullying and harassment and stuff like that. But they've also got really strict rules now with what we can cover. I woke up to that the other morning, flashing on my email, and it's to all creators, not just the true crime community. Everybody got that notice. Leslie says a lot of flapping of gowns in the UK. Wigs would be thrown. Thank you, Sarah Smith, for smashing that like button. We're up to 45. And you guys, what I'm going to do is I'm going to get together another basket and have another giveaway for Valentine's Day. So make sure that you follow. You're subscribed. You have to be subscribed to be entered. So anyone who is subscribed will be entered. It's going to be worth probably about $100 and something minimum. I'm going to put a nice basket together for Valentine's Day and have a Valentine's Day draw where you guys, anytime you make a $10 super chat or more, you're going to get an extra entry. I'm going to have some chocolates in there. I'm going to have some cards, some Oracle decks. I'm going to have all kinds of different stuff in there. I'm going to have some bracelets and some keychains and some necklaces and stuff for Valentine's Day. So make sure that you are subscribed and you get an entry. Every $10 super chat that you give, you're going to get an entry into that. So your super chats don't only help the channel, they are also going to get you entries into that draw. So make sure you're subscribed, hit that notification bell, give this video a thumbs up, and any $10 super chat gets you entered into that draw. And we will hold the draw live, so you guys can see everybody's name on the wheel. We will do that live on Valentine's Day. So once I get the basket done up, I'm going to show it to you. And you don't have to be on a live. You can also use the little heart below any video from today on. And you can also donate there with a super thanks for the replay cruise. My birthday was January 14th, a month early of Valentine's Day. Well, happy belated birthday, Carol. You know what my belated birthday present was? My birthday was December 4th, December 6th. I went for a trip down my basement stairs and broke my tailbone, cracked 2 ribs, and now I've damaged my already injured back even further. So now I'm waiting for my MRI. Finally, I've got a date for it. You're very welcome, Carol. So yeah, so when I get that basket together, I'm going to be probably getting it this weekend. So I'll probably be showing it on Sunday when I have my mini reads where you guys can come and get your very own mini read every Sunday morning, 11:30 a.m. Eastern, right here. I think I will show it then. I just got to make myself a note on my calendar so I don't forget. Oops. I'm just making myself a note as we wait here, you guys. Okay. Got it. If not, you guys, you know me, I forget. So we are still waiting for them to come back. I can just hear John Pryor right now in that breakout room, just stomping his feet, pulling his little bit of hair out that he does have. Oh, thank you. It's okay. I've gotten a lot better. Carol, I am finally able to sit, although if you do hear my chair moving around, that's why I mute myself when court's in session and we've got it up on the screen. Because I stand up, I sit down. I stand up, I sit down. I still can't do a lot of stuff. I still can't bend over and pick up something from the floor. I can't lift anything over a couple pounds. But I mean, it's getting better. It's all part of the process, and I'm happy with how things are progressing. So it is what it is, right? But thank you so much. Me too. And right now, like I was before the fall, I had a back injury where I broke my back years and years ago in a car accident. And it had gotten to the point where they were starting to talk about surgery. Like I got no choice now. Back then I had a choice. But it was getting to the point where I don't have a choice anymore. To be out of pain, that it would need surgery. That's why initially back in May, beginning of June, they said they wanted this MRI. Ended up, they had lost my x-rays, lost the requisition. That's why I've been waiting so long. But in the meantime, since then, I fell on the basement stairs. And I mean, I didn't just go boom, 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 boom down the stairs. I went up in the air and then boom, back down. So now they feel that it's injured my back even more. So now I go February 5th for an MRI to see what is available, what is going to happen. Yeah, my mom lent me hers, Leslie, one of those bender things. But there's things that are heavier that I can't, that those things won't pick up. Nana says, I have to wonder if the judge is wringing Pryor's neck. That's why they haven't come back yet. Oh, thank you, Shar. Oh, you're so sweet. Yeah, my mom has one that she'd lent me. But heavy stuff, it doesn't pick up, so. And then last night, I had to change all the insides of my toilet. So thank God I do have a roommate. Not a roommate, but a boarder. And he's an older guy, too. He's like 67, I think. Doesn't leave his room, really, except to go into the bathroom. He orders all this stuff online. So anyway, I had him come in and have to lift the tank off because I had to take the back of the tank off, change all the innards. And I think now I'm going to have to go and get a new toilet because this one is, even though everything is tight, washers are on properly and everything, it is leaking. It's a kind of a little bit of a different setup than what was initially in there. So I think I'm going to end up having to buy a new toilet, which is not on my list of things I want to do right now. I use it to get stuff from the back of cupboards. Yeah. It's handy. It's very handy. Oh, here they are, you guys. So when the audio starts again, you guys make sure, can you hear it? Put 1 in the chat if you can hear.
Thank you. Please be seated.
Can you hear, you guys?
All right, we're back on the record on case CR 22-21-16-23, State of Idaho versus Chad Daybell. This is a hearing on defense counsel's motion to withdraw. The court conducted a closed portion of the proceedings to make further inquiry, and then in addition, conducted an ex parte proceeding without the states present to inquire of the defendant regarding counsel. And with that concluded, now the defense has presented their argument in support of the motion. So at this time, the court will consider the objection from the state, noting that this was a shortened hearing, so the objection was filed yesterday, which I do find timely. I have read and considered the objection, and Ms. Blake, if you'd like to present argument in support of the objection, you can do that at this time.
Thank you, Your Honor. First of all, the state recognizes that this is a decision that is solely within the court's discretion. I think Idaho Criminal Rule 44.1 clearly outlines that. It does indicate that a motion to withdraw can be granted, or may be granted by a court for good cause. The state also recognizes that the Sixth Amendment guarantees a defendant the right to counsel. There have been additional courts that have reviewed that and provided some additional interpretations, which includes a defendant's right to conflict-free counsel. The state is appreciative of the court conducting an inquiry today because case law also lays out that a trial court's failure to conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. And from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has in fact done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions. One being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance. And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor. What's frustrating for the state is back in January a year ago, both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial. The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right or are advised and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, the state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating, but in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point. The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality is if working 24/7, Mr. Pryor cannot be prepared for trial, what he's indicating is he would be ineffective at trial. What he's presented today is no, I can be effective. The motion says I'm not going to get paid. I want off the case. Today what's being presented is no, I'm fine not getting paid. I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw. The concern for the state is we've had multiple continuances in this case, and I recognize there can be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in around January of last year. Maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a very good idea of what the trial preparation was going to require at that juncture. So again, very frustrated that we're getting here, but we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested. Now here we are again, a couple months. I think today is actually 2 months before we're supposed to start some trial proceedings. And we're hearing a motion again on a request to withdraw, where the representations today differ significantly from what was put in the affidavit in motion. So this does appear to be another attempt to simply get a continuance. So the state's position on this would be based on the representations today. It doesn't appear this is a motion to withdraw. And if Mr. Pryor's representations today are accurate, then I think the motion should be denied. The one question the state has that has not been answered directly to the state, and maybe the court has this information, is there were some conflicting things also represented about Mr. Daybell and his specific position on this. In the affidavit, it indicated he did not want Mr. Pryor to remain on the case, that he wanted to have capital qualified attorneys appointed, that he didn't feel it was fair Mr. Pryor wasn't getting paid. Today, at least from the state's understanding, is we're hearing that Mr. Daybell does in fact want Mr. Pryor to get paid, so he wants him off the case. But then we're also hearing that Mr. Daybell would like Mr. Pryor to stay on the case. And I think that's really the important question today for the state is, does Mr. Daybell in fact want Mr. Pryor removed from the case? He's hired as private counsel. Is he in fact requesting Mr. Pryor be removed to have capital qualified counsel appointed? Because I think that's a different analysis and a different scenario than an attorney asking to be removed. So the state does not know the answer to that. I think we've,
Ms. Blake, I want to be careful because I had an ex parte proceeding, but in general terms, I think it's appropriate for me to advise the state that Mr. Daybell does desire to have Mr. Pryor continue in the case. And as you mentioned, is also very concerned and does not want him obligated to essentially work for free. So that's his overall position in general terms.
and I think that's where we kind of run into an issue. While he may not want him to work for free, Mr. Pryor was hired privately. If a person has the resources to hire private counsel, or if a private attorney decides to stay on pro bono, I think that's the counsel and the defendant's choice. I don't think there's any avenue to allow Mr. Pryor to be paid through another mechanism. I also don't think there's a mechanism that allows a public defender to be appointed to assist Mr. Pryor. I think under the statute, it's if you're indigent and you're asking for counsel, you get a first chair and a second chair qualified appointed. I don't think under the statutes and the criminal rules, I don't see any hybrid system allowed. So I guess the state's concern is if that's the position of both the defendant and counsel, then we should simply be proceeding to trial and this motion should be denied. It's not a true motion to withdraw. If Mr. Pryor is saying I can't be prepared for trial in April, the state's very frustrated that this is clearly just a veiled motion to continue with a different title attached to it. Because that appears to be the true argument today is I need more time. So the state's very frustrated with that. Mr. Pryor's already had a year continuance. I guess from the state's perspective, if Mr. Pryor is going to stay on, we're headed to trial in April. The state's ready to move forward. If Mr. Pryor is saying I can't be effective at that point, then I think capital qualified counsel should be appointed and we should move forward with that counsel appointed and selecting a new trial date. But I don't think Mr. Pryor should be granted a continuance if that's really what's being sought today, and that's what it truly sounds like is being requested.
All right, thank you for
Thank
the argument and response, Ms.
Judge,
Blake.
could I respond briefly?
I was going to allow your response, Mr. Pryor, so go ahead.
Judge, I don't think I've been inconsistent in my representations in my declaration and what was said today. This court took the time to inquire of Mr. Daybell, and I believe what Mr. Daybell related to the court is consistent with what was put in the declaration. The reality of it is this, is that I disagree with counsel, and I don't know what she's reading or how she's interpreting a statute, but this court entered an order allowing the assistance of a second counsel to help in the preparation of this case, and did it some time ago. The reality, Judge, is that although I've made a strong and diligent effort to find co-counsel to help me in this, it's been difficult, and I haven't been able to accomplish that. And the reality is Mr. Daybell recognizes where we are in this thing and what needs to be done in the future. I don't have the benefit of Fremont and Madison County with their 5 attorneys in their prosecutor's office having free reign to do what they want at government expense. And the fact that both of those prosecutors then, in addition to their 5 state attorneys, sought out an attorney from Missouri and at county expense and on the county dime brought an attorney to work on a case that wasn't a death penalty case for the taxpayers of Fremont and Madison County to pay for that attorney, even though it wasn't a death penalty case. And that attorney is still on and still going in this case. And they've expended a significant amount of money. And I suspect it's not at the hourly rate that a prosecuting attorney makes in Fremont and Madison County. I suspect it's significantly higher. And for me to suggest that it's difficult with their 6 attorneys that they're working on this case, and I have to do this by myself, and the court recognized the
You've been
workload.
on a case for 2.5 years by yourself, and
I have.
all these attorneys, and the state carries the burden at trial, and they can prosecute a case they want. I completely agree with the state's position. The timing here, 2 months before trial is going to start, none of this is new at all. The charges have not changed since the indictment. The co-defendant went through an entire trial, which you observed and knew how long it would take. We talked about this concern a year ago, and here we are on the doorstep of trial essentially. And the argument that is not persuasive at all to me is you're just learning now how much work it's going to take. Experienced attorneys, which you are, you figure out how long cases are going to take, and you pick and choose the cases you decide to take as a private attorney. And this argument that they have more attorneys than you, they do. That's what they've elected to do. And you've also elected voluntarily, as has Mr. Daybell, to come on this case and represent him. And you've represented him since the beginning, and in fact, even since before this case began.
And Judge, the issue also is that I per my representation earlier, is that in 2022, I started seeking out assistance and additional counsel. And I made a diligent effort. In fact, I took the extra step of seeking counsel who were death penalty qualified out of the state, out-of-state attorneys. I then tried to find attorneys on the Public Defender Commission list and made a diligent effort. And then when I found one, I believe in October of last year, my expectation is that he would have been on this case by now. But then we come into late December and I'm finding out that he hasn't been approved or put on the list, even though the court authorized the funds, and I'm in this position. As I've said before, Judge, it's not a matter of being ineffective. And for the prosecutor to sort of hint at the fact that I've been ineffective, I would remind the prosecuting attorney that the fact is that, and I don't want to rehash this, but any continuance was the result of them not turning over a lot of evidence, and a lot of evidence that I ended up having to go through and make a determination. So they can't put any continuance on me when it was their own issue in terms of the discovery. The other issues, Judge, are simply this, is that having made that effort to find these attorneys and help me with this case, I recognized that back in 2022. But being able to find someone is a whole different story. And the reality of it is this, is that I'm not making differing statements from what I said today and what I put in that declaration. I've spent a portion of my life representing Mr. Daybell, and I would like to have continued that. But he sees the effort that needs to be go forward. And my expectation was in December or November of last year, I would have had an attorney on by now to assist me in this, and that hasn't taken place. And under our current law, and the way the law is written, and the way the court has interpreted the law, the only way for me to get another attorney and to have Mr. Daybell have the 2 attorneys that he wants, and what it was said in that declaration and what is said today is still consistent. The only way to do that is for me to make the decision to step away from this thing. And to step away from this thing would guarantee and require Mr. Daybell to have 2 additional attorneys. Is it something I enjoy or want to do? No. Mr. Daybell knows full aware how I feel about this case and how I wanted to be involved in this case. There has not been any differing representations to this court. The problem is this, and I recognized, you know what, they get to gauge how many attorneys they want. They get to gauge the amount of money they spend. And in terms of getting assistance for a defendant, I'm bound by the rules and the way the rules are written by our state legislature, and I'm bound by the statutes. And being bound by those statutes, I have no choice. If Mr. Daybell's going to, get the trial that he deserves, either I find someone to help me, which I did starting in with this court in January, but well before that, and to no avail, or I have to make the difficult choice. And I understand it's 2 months before this trial. I understand that. And it's not a choice I want to make. It's not a decision that I want to make in this case. But that overriding want for me to stay on this case, or that need for me to stay on this case, is overridden by the fact that Mr. Daybell should get 2 attorneys to help him with this. I would have liked to have been one of those, but there's no mechanism to do that. So any suggestion that I've been ineffective is ridiculous. This case was severed. This case was transferred to Ada County, and Mr. Daybell would agree with me that I've done everything to strongly and effectively represent him in this case, and he is completely satisfied with what I've done. But there needs to be additional help. And unfortunately, under our current statutes, I don't get that if I remain on this case.
And Your Honor, I just wanted to clarify one thing so we have a clear record.
Go ahead.
The state has in no way insinuated or represented that we believe Mr. Pryor has been ineffective. What we were referencing is based on the affidavit written to the court that we felt that was what was being indicated is if forced to proceed to trial, he would be ineffective because he simply didn't have adequate time to finish his preparations for trial. So I want to make very clear, we are not saying Mr. Pryor was ineffective. I want that very clear for the record.
I understand that, Ms. Blake, and I agree. The arguments have not been any ineffective assistance of counsel. The arguments have been related more towards going forward in the demands of a 2+ month trial and whether, given the concerns raised by the defense, a single attorney, that being Mr. Pryor, would be capable of providing all of the defense necessary for Mr. Daybell in this case. So that will conclude submission of argument on the motion. I'm going to take a brief recess, review a few things, and then I'll come back on the record to make a ruling on your motion shortly.
All right.
All right, Maria. I won't say your last name, but thank you for your PayPal donation. I appreciate you helping out the channel. So basically, I don't know what you guys think is going to happen, but it seems to me like the judge isn't falling for it. The prosecution basically said exactly what I had said. He's had all this time to hire another lawyer to do what he needed to do. He said that he's done everything he can do. No, you didn't, because you could have become death penalty qualified and you didn't do it. So it's just word salad, you guys. And basically, Pryor just trying to toss the buck, but he's got nobody else to toss it to because he doesn't have anybody else on his team. He could have hired another attorney. He could have brought on another regular criminal lawyer. He didn't do it. Never mind death penalty qualified. Just any other lawyer he could have hired on to help him get through all this, and he didn't do it. And just like I had said before this even started, the prosecution brought it up. It's like delay. He just had a continuance of a year. He knew that this was happening. At no time during this last year did he say he can't be ready for this trial. He's had almost 3 years to prepare, but he doesn't have enough time, he's saying. And like I said, he could have hired on another lawyer and brought another lawyer on. He didn't do it. There was so many things he could have done. He could have hired a paralegal to do a lot of things that he couldn't do personally. He didn't do that either. He had so many outs to get ready for this trial. And so many times he said, oh, we're ready to go. We're ready to go. But now he's trying to claim something different. And I think the prosecution brought that up too. And I mean, that's one of the things that I'm really frustrated about. And the two things, like I said, that stand out in my mind is you've had almost 3 years to prepare. You could have brought on another lawyer. You could have got death penalty certified yourself. You said you had all the credentials to do so, but you didn't do it. And hired a second lawyer to take second seat if you got yourself death penalty qualified. He didn't do any of those things that would have kept this trial going. It seems he's doing more to delay than he is to keep this going forward. And so many times, I need a continuance. I need a continuance. I need a continuance. I need a continuance. And I think today is the end of the line for his BS. Yes, and I do believe that they could appoint somebody for that second phase of the trial. Because it's a death penalty case, John Pryor is more than capable of doing the trial itself. The second phase is what they are concerned about, which is the death penalty phase. Okay? So could they get somebody right now and appoint them for the death penalty phase of this trial? It's like a trial within a trial. Yes. Because he said he's more than capable of taking care of the trial itself. It's just the death penalty phase of the trial, which is a mini trial within this trial that comes after the initial part of the trial. They could have somebody available to take first seat for that. And John Pryor shot himself in the foot when he said, I have all the qualifications to become death penalty certified, but I didn't do it. So you got to take it as everything. And I don't know what was said in the breakout session, the first one. We're now waiting for the judge to come back and give his ruling on this. I'm going to put up a poll. Oh, no, it's going to be denied. Okay, so let me get over here. I'm going to put up a poll. Okay, so here it is. The poll is up. And the poll is, will the judge grant John Pryor's motion to step down as counsel? Everybody get voting. We're going to leave that up for a little bit, and we're going to see what you guys think. I say no. I think he's going to be made to stay on this case and do at least the trial portion, and probably get somebody to step in who's death penalty qualified, or he's going to suggest that John Pryor get death penalty qualified to do the second part, which is the penalty phase, the death penalty phase. So, and he has always said, just like the prosecution said he's got this. He can do this. He can do the trial. It's just the death penalty, the penalty phase, that he's not qualified to take first seat in. So are they going to bring somebody else in first seat, and he's going to have to take second seat? We discussed this before the hearing even started today. So I'm anxious. I'm watching this poll. So far, 6% think. Courtney. I can hear Pryor talking to that spineless twat. Yeah, I want to do this. I'll do this free. I don't care about the money, but I want to get paid. I want to get paid. Does Chad want me to get paid? I want to get paid. I want to get paid. But I'll do this without getting paid, but I want to get paid, but I want to get paid, but I want to get paid. I don't know how many times he said that. And it's like his filing and what he's saying now totally contradicts everything that he said in that motion as to why he wanted to step down. He said he cannot continue. He's not going to be ready, number two. But number one was he wasn't getting paid. Yes, they do have court-appointed death penalty lawyers. 10% think that the judge is going to grant John Pryor's motion to step down. 90% say no. Yeah, Sarah Smith says Bad Monkey Videos. Get ready to read John Pryor's books and Netflix series. Right? It's crazy, you guys. It's crazy. It's absolutely crazy. Thank you, everybody, for smashing that like button. Make sure that you are subscribed so you don't miss anything. The next one that we have that I'm going to be live streaming, you guys, is on the 26th. That's Brian Koberger. He's back in court. They are going to be arguing motions. The defense is going to be arguing their motion to stay and to appeal the judge's orders regarding the grand jury indictment, as well as other things. Also, what else was there? Oh, Brian Koberger, if you didn't see my video from a couple of days ago, go check it out. Brian Koberger has filed a motion to start having things unsealed. Go watch that video if you have not seen it. I think I put it up yesterday or the day before. So he now wants things to be unsealed. It's not fair that the public is not seeing certain things, blah, 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 blah. But it's like, you guys are the ones that pushed for everything to be under seal. And now they're changing their tune a bit. Why are they changing their tune? They're changing their tune because they lost their motion to have the grand jury indictment thrown out. So the judge did order that in the Brian Koberger thing, the judge did order that the prosecution has to hand over some of the IgG testing stuffs. Now, I'm going to tell you right now, and this is my opinion and my opinion only. I'm telling you, they cannot force the FBI to hand over certain materials or tools that they use to break down or find suspects, stuff like that. The FBI did certain things like submitting the DNA that they found on the sheath to 23andMe and this and that, and I'm related to you, you're related to me, those sites there. And they found a family member associated with that DNA. They called it in they didn't call it in, they didn't call it in, but they probably picked up the phone and said, hey, buddy, called up their buddies at the PD and said, hey, here's a tip for you. Follow up on this tip because the IgG, whether they said IgG or not, I'm assuming they probably did. We've got a tip for you that DNA found on the sheath is connected to Michael Koberger. It's male DNA and it's an offspring of Michael Koberger. Look into it. That's their tip. They don't have to divulge how they got that. And to me, basically, it doesn't really matter how they got it. They found Brian Koberger off of, number one, after seeing surveillance videos, and there was this white Hyundai Elantra, which Brian Koberger had, other things that they did, and then to get a tip from the FBI saying that it's an offspring of this Michael Koberger, you're going to want to look into that. So then that's when they started, okay, well, we got video, we got this, we got that. We got pings, he was in the area. Okay, so what did they do? They got garbage from Brian Koberger's parents' house and tested that against the DNA found on the sheath, and bada bing, bada bang. So then when they arrested Brian Koberger, they took that buccal swab and it matched the DNA on the knife sheath. So does the FBI have to give up how they were able to give that tip? No. And I don't think they can be forced. Willow, you should send those Idaho mixed up files. I already showed it on here. I already showed it. It's on my community tab. And I'm sure I also put it over on Twitter. And I'm sure somebody over there is going to screenshot it and they're going to send it to the courts. Let me just see here. Give me a second, you guys. I don't know if I can. Hang on a second, you guys. I don't know if I can send them an email. I'm going to send them an email. Hang on a sec. Give me a second, you guys. I can't see any of the chat. Just give me a second here. Okay, hang on a sec, you guys. Okay, I'm going to send it to them. There we go. I sent them an email saying that it needs to be corrected, that some of Chad Daybell's court records were entered into Brian Koberger's file. Butterfly Dana, what are you talking about here? He said, and thank you to the person who gave that tip. What are you talking about, hon? I'm not sure I know what you're talking about. I did. I just emailed them and said that they put files of Chad Daybell's in the Brian Koberger. Yes, it was his father's DNA. What had happened was when they entered the DNA that was found on the knife sheath, they entered it into CODIS. There was no match, which means that there was nothing in the system that matched that DNA profile. So then they went to these IgG places like 23andMe and Ancestor. You're my friend, you're my family, whatever. And they got a partial match. And that match was matched to Brian Koberger's father, Michael Koberger. So what happened was they knew that the DNA that was on that knife sheath was somehow connected to Michael Koberger's offspring, a male offspring of Michael Koberger. So what the FBI did with that is they called up the local PDs and said, hey, here's a tip for you. You might want to look into this because we got Michael Koberger. It's his offspring, a male offspring of this of Michael Koberger. So when they checked into that, oh, he has a son named Brian Koberger. And guess what? Brian Koberger also has a white Elantra. Brian Kohlberger's phone. They already had Brian Kohlberger's phone number from previous stops. And when they looked into that, his phone was in the area 12 times. And then it was going towards the Moscow, Idaho house at 2 something in the morning, the night of the murders. Things started coming together. So what did they do? They went out to Pennsylvania and they got some stuff out of the trash. They tested that. The DNA that they got off the trash was a match to the DNA on the knife sheath that said that this is the father of whoever's DNA is on that knife sheath. So then that's when they arrested Brian Kohlberger. When they arrested Brian Kohlberger, they took a buccal swab. If that buccal swab would have came back not a match to the DNA on the knife sheath, he would have been let go. They would have had to search for somebody else, but it was a perfect match. So that buccal swab that they took from his mouth matched the DNA on that knife sheath. Ba-da-ding, ba-da-dang. Now, the FBI does not have to disclose how they came to be able to give that tip. So that's why I believe in the judge's orders that they have to give partial IGG information. I just explained that to Butterfly Dana. Showbell. Hello, my love. Nice to see you again. Haven't seen you in a while. Sarah Smith. Sorry if I'm missing anybody here. Carol M. Hello, hello, hello. Hello, everybody that's come in. Ocean Surf Girl. Hello and welcome. Lori Forbes. Hello, hello. Hello, everybody. Sorry, I probably missed a bunch of views coming in. Leslie. Frasia. I'm trying to see and I'm trying to give shout outs. So hello, everybody coming in. The judge is having a meltdown. It's like, in the corner for you, in the corner for you, no phone for you, no phone for you, no phone for you. No, there's already precedent set regarding this. So the judge is going to be going by the precedents that were already set regarding this issue. And I think the judge brought it up a couple of times about precedences that were already set in cases like this. Give me a second, you guys. Okay. I'm going to put my camera on for a minute, you guys. And I'm going to do this. I'm going to show you guys how far this is what I've been doing in my spare time. Not that I have a lot of spare time. This is what I've been doing, you guys. Look at this. This is the diamond paintings. This is one of the ones that I got from Temu. I said I'd show you guys. While we're waiting for court to come back, I'm going to show you. So this is how much I've got done of it so far. And they do send you the piece for the clock. The only thing I didn't like in this is I noticed when I got to here was, wait. Oh, I think they're coming back. Yeah, okay, they're back. Okay, are you guys good? Can you see it? Put a 1 in the chat if you can see and hear it, please. Okay, 81% of you guys
All right,
think
confirm
that
the live stream's begun again.
he's
We are
not
back
gonna
on the
be,
record on
that it's gonna be
KCR
denied.
2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th.
Cross your fingers, you
Considered
guys.
the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor. And I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. And I'll just quote that section. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell importantly does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases. And while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued. And I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any
Exactly what I've been
review of
saying.
discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the 2 concerns here raised in the motion really are, number 1, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor's indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client, although it may be difficult and he apparently will not be able to be compensated. It's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied, and Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today, and I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge, thank you for your consideration.
All right, thank you. Ms. Blake, any questions on the court's ruling? All right, thanks everyone for your attendance. That will conclude today's proceedings. We'll be in recess.
All right.
Booyah! I kind of like it, you guys. I gotta admit, all these lawyers on YouTube saying I didn't know what I was talking about. And I'll pat myself on the back. Exactly what I was saying. They're going to appoint another lawyer for him. Somebody's going to have to take second seat. Probably going to be Pryor, and he ain't going to like it. But exactly what I said I thought was going to happen has happened. And like I said, even though Canadian law differs from the law in the US, there's a lot of things that are the same. And if one of the lawyers that I worked with ever tried to present something like this, I would say, deuces, I'm out. I ain't going to be no part of that motion because it's bogus. Right? Nailed it. I wonder if any of them are going to apologize to me. Probably not, and that's okay. Like I said, yes, a lot of the times there's differences in Canadian law compared to the US law, but there's also a lot that's the same. I could not in my right mind ever think that the judge was going to allow this. There's just been so much put into it. Chad has lost, including the shirts off his back, because it's the same shirt he's been wearing for the last 2 years with the red tie. He's got nothing left. And at this point, like the judge said, he's been behind bars for almost 3 years. He's in a comfy jail. He's not in prison yet. But he's going to go to prison. It's inevitable, right? So it turned out exactly the way I thought it was going to. Thank the good Lord. And like I said earlier, somebody had asked about precedent with this set of precedent. This precedent was already set. So why the other lawyers didn't see that, I don't know. But I don't know. I just had a really good inclination this is what was going to happen because all the laws pointed to that. And don't forget, every state has different laws on how they deal with stuff like this. I did look a little bit into Idaho law when I started being told that I was wrong, that this is not what was going to happen. So I started looking into it, and it says, well, everything I've read and the way I interpreted it and understood it, I was right with what I said. So I didn't understand why they were, trying to say what I was saying was wrong. But I figured they're U.S. lawyers and they know the law in the U.S. better than me. So it's like I kind of started second guessing myself. But I still stuck to it. Even before this started, I said, I'm still sticking to it. I'm sticking to what I said because that's what I felt was right. So I'm going to be interested. I think I'll go and check out a couple of their channels later today after they've had a chance to see what transpired today and see how they backtrack. Because they were adamant that, no, he's going to be allowed to get off the case. Yeah, Pryor can sleep under his desk now. Sarah Smith, thank you. Thank you. Shell Bell, thank you for stopping in. I appreciate you. I appreciate each and every one of you guys. Like I said, if you have not subscribed, please hit that subscribe button, hit the notification bell. There's going to be another hearing coming up. I will watch the docket to see when that's happening. The next one so far that I'm covering is going to be next Friday, not this Friday coming, the following Friday on the 26th. And that's going to be the Brian Kohlberger one. We're going to be able to see it just like we've seen the Chad Daybell one today. We're going to be able to see what happens live. I will be covering that one too. It starts at 1 p.m. Idaho time. So I think that's either 3 or 4 o'clock Eastern. I think it's 4 o'clock Eastern. So I will be covering that one also. Again, thank you very much, Sarah Smith. I really appreciate you. It helps me to continue being able to do this for you guys. If you want me to continue, help out with some donations. So I've been online now since 4 hours now. It takes a lot of time and effort to be able to do this. So I do appreciate all your support. Thank you. Thank you. So where are we? We are Thursday. I'm going to try and get a read up, you guys. It's going to be an updated because there's really not much going on in the true crime community, but I've been asked to do a couple of updated reads. So I think I'll do them. They'll probably be posted. One at least will be posted by Saturday. I'll do it tomorrow because today I've got to run out and pick up a few groceries. So I don't have time to do it today, but I'll do it. I'll do the read. I'll probably do a couple of reads tomorrow so I can release one on Saturday and then one maybe on Tuesday because I have the live mini reads where you guys can come and get your very own mini read. I have that every Sunday, 11:30 a.m. Eastern. You can get your very own mini read, so come and join us for that. So that's that. Denied. Again, thank you, Sarah Smith. I appreciate you. Denied. The judge denied it outright. No, you're not wasting no more of our time. We're going to trial April 4th, and I will be covering that whole trial also. So I'm going to try and get a bunch of reads done up, you guys, before that, as the months progress. Probably in March, I will do a whole bunch of them, do them up, and then release them throughout the trial. So you guys aren't, for the ones that are here for the reads, you guys won't be missing those. And then I will be covering Chad Daybell's trial. It's going to be interesting, you guys. Yes, thank you, mods, for being here. You guys rock. You're the best mods ever. Thank you all for being here. I appreciate each and every one of you. And I will see you guys again Sunday morning, 11:30 a.m. Eastern, right here for mini reads. I love you guys to the moon and back. Please stay safe. Always be aware of your surroundings. Love you to the moon and back. Bye-bye for now. Thank you, Lori. Love you too, sis. Bye-bye.